Good morning. Welcome to day 8 of our hearing. Before we continue with the testimony of the expert, Mr. Rybowski, are there any housekeeping issues from claimant or respondent side?
No housekeeping issues for us. Thank you.
Thank you.
No housekeeping issues for respondent.
Then, Mr. Prager, please continue. Please continue with your cross-examination.
Thank you, Madam President. Claimant doesn't have any further questions for the expert at this time.
Okay. Any questions on redirect?
No, Madam President, no questions on redirect.
Do you have questions? Do you have questions? Then we may add just a couple of questions from my end. The claimant's expert yesterday named the stability agreement a short little agreement. And I understand you in your expert saying the key to the scope of the agreement is the language in the agreement itself, and you refer to an exit case. It's an exhibit RA88, is the case Aguayatia Energy versus Peru. Can you explain why you think this is something and a decision we should consider?
Sure, that was a case. Oh, I'm sorry. Of course, I assumed it was on. Everything else was ready. Good morning. Aguaita was a case involving Peru, and as I recall, it was power transmission lines. And it was an arbitration very similar to this. And they had a stability agreement, and there was some action taken by Peru subsequent to the agreement. I think it was some most favored nation rules that Aguaita thought they should come under because of their stability agreement. And the tribunal held that that stabilization agreement at that moment in time froze things at that moment in time. It didn't provide any further future benefits. So that was the relationship I saw to this case, is that the leaching project is as of the date of the feasibility study and the stability agreement, and claimant is coming along 8 years later with new facts, a new project, and trying to relate it back. And that was the similarity that I saw.
That was a similarity, but it has nothing to do with the mining law, right?
No, ma'am. It was a power transmission case, yes.
Okay. Then there was another statement of Mr. Otto yesterday on which I would like to have your comments. He talked yesterday about a worldwide presumption that stability agreements cover all investments in a mining unit. And my question is, and I think you made reference to certain jurisdictions in your second report, in particular Argentina, Indonesia, and Mongolia. Do you know of other jurisdictions where the mining laws provide for a mechanism restricting the scope of stability agreements to individual investment projects instead of the entire mining concession? And I really want to ask you, as an expert from your own experience during your time at PwC's Global Mining Tax Leader, so I would like you to be very specific on that.
Sure. I've not had to face this issue in a stability agreement either. I'm familiar with the mechanics and the need to separate things, and I looked at all the countries that Mr. Otto cited and reviewed everything he provided, and there are very clear examples in there where it talks about this is limited by what's in the original agreement or what's in the feasibility study. None of those were a situation where something started and then something completely out of the blue came later. They were all contemplated at the beginning and included at the beginning.
But so if I understand you correctly, this is nothing that you worked on during your time as FPVC.
I've not had to face this in a stability agreement either.
Okay. And then my final question, it relates to slide 12 of your presentation that you gave yesterday, in which you showed the different products and values over time and wanted to alert us to the economical impact that the concentrator had. And I just want to better understand, did you, in preparing your report, also study the claimant's economic expectations at the time, including the 2002 feasibility study, or was it not part of your expert report?
Could I first get slide 12 up to make sure
Yes, sure.
we're talking about the same thing? Gavin, can you help me out, please?
The three different colors, red, black, and green.
Oh, okay. No, I know where we are now. All of those numbers came from claimants' feasibility studies. The 96, as you see it right, the title, different products, and then saleable copper per the 96 and 04 feasibility studies. This is all data out of those feasibility studies.
And is it the data regarding the 2007 prices that came from the 2004 feasibility study, or did you also study the 2002 pre-feasibility study?
No, I did not. And the 2007, those green lines are my math, because the feasibility study was done in 04 when it was 90 cents a pound. But I realized that, as I said yesterday, when it came time for them to complete the tax return, to actually, okay, we're going to do this, that was the price of copper. So that is my math. What I got from the feasibility studies is the volumes of saleable copper, because that's what the engineers were doing, the prices of 90 cents. The $3.28 was, I believe, I took that, it's footnoted in my figures, but I believe it was Freeport's average copper price for the year of 2007. And so, I'm sorry, I did not relate it back to the pre-fees.
Okay, thank you very much. This is understood.
Can I make a follow-up question?
Yes, please.
Why is the issue of price relevant for us in interpreting the stability clause? Does it have any relevance? Is it different, the stability, if the price of copper has increased or decreased?
The relevance to me as a tax advisor and someone who helps people develop strategies and put things on returns is when you're actually completing that return, you're dealing with the facts at that moment. So does that help?
No, I would like to you answer my question. I understand what it's relevant for you as tax advisor. The question is if it's relevant for us in deciding the scope of the stability agreement.
My primary point for you as the tribunal is to help you understand that the real value of this, that claimant, and I don't mean this as a wise guy, that claimant wants to get under the 98 stability agreement through the back door. Let's just put it in the beneficiation concession instead of going and asking for a new stability agreement in 04, that you look at the values of what was included in the stability agreement based on the feasibility study of 96 and the agreement of 98, and what actually it turned out to be.
I understood. Now, as a tax expert, is it relevant for us in determining the tax stability agreement, the price of copper?
I think it is. I think all of these things are taken in their totality as to you're being asked to allow claimant to take something they specifically disclaimed in 96 and 98 and weren't able to prove up till years later and say that it's included. And I think the magnitude of that is something that anyone should be looking at if you're trying to consider it. So I very much do.
Thank you.
Any follow-up questions by the parties?
Just a couple of very brief follow-up questions, Madam President. Mr. Rabowski, I wanted to ask you about the Aiguatia versus Peru case you were just discussing with the President. Are you aware that the stability agreement in that case was a legal stability agreement, not a mining stability agreement?
Could we pull that up where I had it in my report, please?
Well, I mean, you were just talking about it without having it in your report.
And you've asked me a different question. Could I see it, please?
Sure. Can I have? It's in your report, which is in your small binder there.
Oh, okay.
If you'd like to open
Yep.
up, it's your first
Do you remember the
report.
paragraph, please? Oops, sorry. It was the second report, correct?
It's your first report.
Oh, okay.
It's paragraph 43 of your first report.
Ask your question is,
Do you understand that the stability agreement in that case was a legal stability agreement, not a mining stability agreement?
I honestly don't recall.
And do you-
I
and do
read
you-
it at the time. Sorry?
No, I'm sorry.
I read it at the time. I don't recall right now.
Okay. And do you realize that legal stability agreements are governed by a completely different legal regime from mining stability agreements in Peru?
I believe the principle is the same, and that's why I cited it, that it's limited to the agreement.
Thank you. No further questions.
I have no follow-up on that. I think he answered that specifically.
And thank you very much. This concludes your testimony. You are released as an expert. Have a
Thank you
good
very
day.
much.
And we can then right away continue with Ms. Vega.
We just need a couple of minutes to reorganize
Sure.
ourselves.
Sure. Then let us continue. Welcome, Mrs. Vega. You already know us. You have seen us in action for a couple of days, so I do not need to introduce ourselves. Please be so kind to read out the declaration.
Declaro
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Do you have your expert reports CER 5 and 10 in front of you and can confirm that these are yours and they are correct and do not need to be amended?
Sí, señora presidenta, aprovecho porque
Yes, Madam President, I take this opportunity because I would like to make a small correction in my first report at paragraph 29. There is a conjunction that says or, and it should say and.
Thank you. This is noted. Presentation?
Sí.
So please go ahead.
Yes,
gracias.
thank you. Good morning, Madam President. Good morning, distinguished members. My name is Maria del Carmen Vega. I am an attorney with more than 30 years' experience in foreign investment, stability, and corporate law. The claimant's attorneys asked me to drop an expert report on the scope of stability under the general law on mining and its regulation. This was because I'm the author of the single text of the mining law, the single unified text, and I worked on the package of laws, the reforms that were undertaken in the 1990s to promote investment. I'm going to begin my presentation now. My presentation will address the scope of stability agreements under the mining law and its regulations. I've divided my presentation into 4 parts. In the first, I'm going to address the background and the history that preceded the mining reform. In the second part, I'm going to discuss the scope of stability agreements under the mining law and its regulations. In the third section, I'm going to talk about the application of stability agreements by the Ministry of Energy and Mines and Mining to mining units. And finally, I'm going to refer to SUNAT's application of stability agreements, the tax authority, to mining units. As regards history and background, as you know, the law that amended the mining law in force up until then, the past law dating to 1981, took place in 1981. In that decade, at the beginning of that decade, Peru was experiencing one of the worst crises we've had thus far, not only an economic crisis, as you can see, with terrible macroeconomic indices, inflation over 4,700%, contraction of production, but also a political and social crisis due to terrorist attacks and terrorist groups, which, after destroying the country's infrastructure, were moving more and more closer and closer to the cities. There was a great deal of corruption. The environment was not at all favorable for investment. What the new government did was to undertake first an economic adjustment program in order to turn these disastrous economic figures around, and then a program of structural reforms which were carried out through a number of laws, more than 100 laws that were adopted to promote investment, the objective of which was for private investment to be the driving force of development. Equal treatment for national and foreign investment was guaranteed as among the activities of the state when it engaged in business vis-a-vis private parties. It was defined that the state's role in the economy was subsidiary, and therefore a very aggressive program for privatization of state enterprises was pursued. And finally, a number of principles and specific rules for administrative simplification were adopted. It's in this context that Legislative Decree 708 law for promotion of mining investment was adopted, and that introduced several major reforms to the then in force general law on mining from 10 years earlier. It was in this law, it was decreed that promoting investment in mining was in the national interest. A number of incentives were put in place for mining investment, and a number of principles were enshrined, which I mentioned, for administrative simplification. On this point, I would like to note that what was sought with the administrative simplification measures was first to curtail bureaucracy, second to reduce discretion, and end corruption. What for? So that there could be predictability, so that there could be legal certainty in terms of what's being applied, and equal treatment for all regulated parties. What was sought was for public officials to not have decision-making capability in respect of certain matters, such so as to decide one thing in one case and something else in a different case. So the idea was to do away with that. And at the same time, many procedures were simplified and standardized. In addition, form contracts or adhesion contracts were adopted so that everything could be provided for and nothing could be left up to the discretion of public officials. Now, as regards the scope of stability under the general law on mining, well, for me, there are 5 articles that are relevant for purposes of determining the scope of stability. 2 are set forth in the law and 3 in the regulation. But before explaining these, I would like to explain a few general aspects of the general law on mining. The general law on mining establishes that mining is an activity regulated by the state. It is the state that decides what are mining activities, and the general law on mining establishes that mining activities, exploration, exploitation, beneficiation, processing of ore, is done through the concession system. That's the basic rule. Now, in terms of the scope of mining stability, the first relevant article is Article 82. This article came from the previous law, which referred in the first paragraph to the minimum requirement of production capacity to be able to sign a stability agreement in the case of large-scale mining. But one of the jobs that I had to carry out in systematizing the single unified text was to adapt the changes that had been made, because under the previous law, these contracts of large-scale mining did not have an established term. But the new law established, among the various measures to avoid discretion and all, that it's a fixed term for all large-scale mining, which is 15 years, independent of the amount of production capacity. Once one attained the minimal amount, all stability agreements had a 15-year term. So this article is interesting because from the outset it sets forth what stability agreements seek, which is that they are done to promote investment and to facilitate financing of mining projects. Here we see that mining project is used as a synonym for economic administrative unit, mining unit. And in the second paragraph, which was also in the original law, the previous law, because that is the one that defines the scope of the stability of these agreements, well, I also had to reorganize there because it was just loose floating about in the previous law because of the changes that had been introduced. And I had a specific meeting with the Vice Minister of Mines in order to determine where it would be best to place this part, which was an article of the previous law. What the second paragraph says, and here we can see it better, is that for the purposes of mining units, or the mining law, the term economic administrative unit means the set of mining concessions located within the limits set forth in Article 44 of this law. I'll explain this later, plus the processing plants and the other assets that constitute a single production unit. This is the basic principle, that these mining concessions, these processing concessions, and other assets constitute a single production unit. Why? Because they share supply, administration, and services. And what is interesting is that in each case, it must be characterized by the DGM. There are 3 things to emphasize the question of the economic administrative unit of Article 82 is a broad concept that needs to be doesn't need to be characterized. It doesn't need a resolution of approval from the DGM, as I'm going to explain next, comparing it with another similar concept that but which has a different purpose and which allows one, guarantees that in these production units one be able to make investments continuously, which is how mining works. As I said, there's a reference here in the definition to mining concessions that are indicated within the limits set forth in Article 44. Why? Because under the general law on mining, there are other types of another type of economic administrative unit, which are under a different title and which are for different purposes, and which only allow one to group mining concessions, as opposed to the broad concept of economic administrative unit for purposes of stability, which includes both mining concessions and beneficiation concessions. In this case, the Article 44 EAU is simply a provision that makes it possible to consolidate minimal amounts of production so as to be able to comply with the requirements set out in the law. Now, in this case, one does need to have a resolution of approval from the DGM, in contrast to the EAU under Article 82, which only requires a characterization in each case. This, in each case, is the respective agreement, as we'll see. And let's continue with the second article. The second article, this article was a new one, part of the reform. It's been mentioned on other occasions, but it includes as a requirement in addition to production capacity that one comply with a minimal investment amount in order to access stability. And then in the first paragraphs, it refers to the minimal amounts of investment that must be reached. The relevant article for determining the scope is the fourth paragraph, which says that the effect of the contractual benefit, that is to say of the stability guarantee, shall apply exclusively to the activities of the mining company in whose favor the investment is made. Now, this exclusively refers to activities of the mining company. Now, which activities? The activities which we've said are provided for in the law, which are exploration, exploitation, beneficiation, which are carried out through the concession system, as I've indicated. But let's see how later the regulation sets this forth in greater detail. Now, I would just note that in favor of which the investment is made, well, at least in Spanish, it's striking how it's worded, but as has been mentioned, I believe one of the witnesses for Peru and one of the witnesses for the claimant as well. Well, the explanation is that up until that time, the state engaged in business activity in a big way in mining, and it did so through mining company conglomerates. So there are different holding companies that would invest in the different units, and what the idea was to make it clear that this mining company, to which reference is made, and which enjoys which is the one that has stability, are the ones that directly receive the qualified investment, and nothing else, just that company. A year after the single unified text went into force, the regulations were adopted, and this is the regulation on mining stability, and it implements the scope of stability guarantees. This regulation reflects the understanding at the time regarding the scope of stability. It has been in force for almost 30 years without undergoing substantial amendments. In 2019, it was amended in light of the change to the mining law that took place in 2014, and which incorporated Peru's restrictive position regarding the scope of stability. And, as I said, it develops the law, and it expressly defines the mining activities that enjoy stability. There are three relevant articles. The first is Article 1, and it says textually that tax, exchange rate, and administrative stability set out in the general mining law are the guarantees of juridical security that are granted to the holders to the mining title holders for carrying out their activities. Let's see how This is set forth in the second article with greater emphasis. Article 2 says that the provisions the provisions of the stability regime apply as of right to all mining activity title holders who are defined as the natural legal persons who perform mining activities. And there it says that specifically stability is given to the title holders who perform mining activities in a concession or in concessions group in an economic administrative unit, so long as they enter into a stability agreement for a 10 or 15-year term, complying with the requirements set out in the law, obviously.
The interesting thing here is the last paragraph of this article, Article 2, that was not modified. This is the original article in the regulations. And that it says when the mining company is a title holder of several concessions or economic administrative units, the qualification will only take effect for those concessions or units that are supported by the contract or by the agreement. That is why at Clause 3 in the model contracts or model agreements in Exhibit 1, you see which concessions or mining units are stabilized.
No sé qué pasó. I don't know what happened. Okay. Bueno, por
Lastly, could you please repeat something you said? What is the reason for the reform in 2019 of the regulations? Well, as you know, the General Mining Law in 2014, when all of these SONAT assessments had been made, well, that was reformed. It was amended to introduce some amendments that had to do with the scope of stabilization contracts for mining. That provision reflects the restrictive position adopted by the state. Years later, a regulation was enacted to make it operational, and this is the regulation that reflects those changes that had taken place. Thank you. As I said, the last article is Article 22. It has been cited by a number of experts and witnesses from both parties. This article says that contractual guarantees shall benefit the mining activity title holder exclusively for the investments that it makes in the concessions or economic administrative units. It says this very clearly. The ones that are stabilized are the investments made in the concessions or economic administrative units. As we've seen, the economic administrative units are a broad concept, and it is provided in Article 82, and an EAU is understood as a production unit. The second paragraph is very important, and I will cite it later in the examples I'll provide for SONAT and the DGM as well. It says, to determine the results of its operations, the mining activity title holder that has other concessions or economic administrative units, that is to say others different from the ones that are stabilized, only in that case, it shall keep independent accounts and reflect them in separate earning statements. The only reason is for other concessions or economic administrative units to exist that are different from the ones that are stabilized. It doesn't say another project. It just says other concessions or economic administrative units.
Bueno, ahora voy a pasar a explicar el...
I will now talk about the MINAM's application of stability agreements to mining units. It's not working. I first wanted to establish clearly and that the DGM is the agency of the MINEM that is the most relevant for stability purposes. The DGM is responsible for supervising the different agencies, for example, audit, mining promotion and development, and mining oversight. And the DGM has a number of authorities, for example, to grant titles of beneficiation, mining transportation, and general labor concessions, and also their extensions to approve the technical economic feasibility study that the mining company has to submit to qualify under a stability agreement. And the last one is very important, to ensure compliance with tax stability agreements. Let me emphasize this. The functions of the DGM are not exhausted by the simple approval of the technical economic feasibility study. No. This has to exist during the whole life of the stability agreement. Let us now look how is it that in practice the DGM exercises its authority to make sure that there is compliance with the stabilization agreement. The model contract has a clause number 3, that talks about the scope, and it sends us to Exhibit 1 in connection with the concessions that are part of the mining unit and that are stabilized. The second paragraph of Clause 3 of the model contract says that new mining rights may be incorporated in these EAU that are stabilized, and for that you need the approval of the DGM. Let's look at a case here where a mining company that has a stabilization agreement that was signed and a mining unit, the PARCO unit, stabilized, that is made up by the beneficiation concession and the mining concessions, asks that under paragraph 2 of this model contract, it asks for the incorporation of new mining rights to its stability agreement. The interesting thing is here that the Mining Council, this is the second instance here, which is the agency of the ministry in charge of deciding administratively resolutions that come from the DGM and other agencies. Well, I was saying it's interesting because what the Mining Council says that the concessions created in the PARCO EAU and the PARCO plant beneficiation concessions are included in the stability agreement. So it shows that stability includes the mining and beneficiation concessions that are part of the unit, and they say Project PARCO here. Now, the request by the mining company of incorporating new rights to the stabilization agreement, well, that's going to have some implications because the benefits have to be given to the new mining rights, and that's important. The second case has to do with a 2003 case that the DGM addressed, and a mining company that already had a stabilization agreement that had been signed, and that the concessions, the mining concessions and beneficiation concessions were stabilized. Well, that company asked for a new stabilization agreement for the construction of a leaching plant in a different concession, different from the one stabilized under the other contract. So they were going to process ore that was already accumulated. So it is asking for the mining concessions, the beneficial concessions, to be entered into the included in the new stabilization agreement. What the DGM says at the time when deciding this, that Article 82 that includes a broad concept of EAU, understood as production unit, defines for purposes of the stability agreement what is meant by UEA. That is to say, it is the group of concessions included. And it is recognizing that for purposes of stability, this definition departs from the classic definition of EAU, which refers to grouped mining concessions, whereas for stability agreements, they do not necessarily have to be grouped together. Also, it says that these units, these mining units, these production units may be made up of beneficiation plants, or they may stand alone. And this is consistent with Article 83. It considers that in itself a beneficiation plant may also be a production unit. In this case, they were treating ore that was accumulated, but there was going to be no production. So the new plant is, in and of itself, a different production unit. And since this is a different production unit and the other one was a separate production unit, each one has to have its own stability agreement, and the results financially have to be separated as well. The Mining Council has to decide administratively all these requests for review, and it also standardizes administrative jurisprudence regarding mining issues. I'm going to make reference as well to Sociedad Minera Cerro Verde. As you know, Sociedad Minera Cerro Verde signed in 1998 a stabilization agreement under which the mining unit of Cerro Verde was stabilized. And this was made up of Cerro Verde 1, 2, and 3, and the beneficiation plant of Cerro Verde. It signed the stabilization agreement, and in Exhibit 1, it was indicated that the DGM indicated that these two concessions made up a mining unit, and in 2001, Cerro Verde asked the DGM an extension of its beneficiation concession because there was an increase in the number of hectares and also in the production capacity. After looking at the file, the DGM considered that the requirements were met, and consequently the extension or expansion was allowed. Then Cerro Verde, on that basis, made new investments that were not provided for in the feasibility study. What happened then? SUNAT made no objections, and it considered that they were included in the stabilization agreement. Then in 2004, Cerro Verde submitted a new request to the DGM to extend or expand the concession because it was going to build a concentrator inside the beneficiation concession, and that would be the mining unit of Cerro Verde. Why? Because the surface area was going to be larger, and the production capacity also was going to be larger. So the DGM looked at the file, provided authorization. Cerro Verde started the construction of the plant, and then SUNAT adopted a position that was completely different from the position it had before, in spite of the fact that the plant was built inside the same beneficiation concession that was covered by the stabilization agreement. Lastly, I'm going to provide a practical example of the application of stability agreements by SUNAT to mining units. I'm going to talk about Milpo. I think this was mentioned here as well. Milpo had 3 mining units: Cerro Lindo, El Porvenir, and Chapi. That was not in production. Chapi was not in production. The company had stability agreements, and we're going to see what happened. In the fiscal year 2003, there was an audit conducted, and As a result of it, in 2005, the tax administration established a number of objections and then issued an assessment. And a number of objections were made, observations, and the tax authority, as you can see, made a distinction when determining the income tax by mining unit. If you look at the left, where it says Unit El Porvenir, it applied a stabilization regime with a different rate that was different. And then it says here, other units. Why? Because it's doing what Article 22 of the regulations obliged it to do. When a mining company had other units, that mining company had to determine each one of the units. Here, the tax authority says that Unidad El Porvenir unit, you see here, there is a footnote, and the footnote says this mining unit, and it uses these synonyms, has a taxability agreement entered into with the Peruvian state, and the income tax was stabilized, and the rate of 20% was applied, which was the current rate for that fiscal year. What we see clearly is that they have separated out each unit at the time that unit was stabilized vis-a-vis the others. Cerro Lindo also had a stability agreement, but it's not there. Why? Because the agreement was not in force at that time. And the second thing is another case that involves Milpo, but for the 2010 fiscal year. And here, Sunat again decided a first-level claim, and we can see how, when deciding the case and evaluating the case, Sunat made a distinction and separated out each one of the mining units. Cerro Lindo at that time had the stability agreement in force, and what we can see that the name of these mining units is EAU El Porvenir under Article 82, and then there's a footnote that says the application of the different rates reflects the provisions of the agreements. Stability agreements. So at the time of the assessment under Article 22 that regulates Article 82 of the law, a determination must be made that is independent for each one of the mining units, because each mining unit has its own stability agreement. And that is the end of my presentation. Thank you.
Thank you very much. So we start with the cross-examination.
And with your permission, I'll turn to Spanish.
Good morning, Ms. Vega. Good morning. It's a pleasure to see you again. Likewise. Of course, we've done this before, just to remind you that there is simultaneous interpretation, and also there are stenographers. Please speak slowly. This will behoove you and me. And then there has to be a pause between question and answer so that the translation can catch up with us. I'm sure Council told you we are very short on time, and I'm going to ask you to please answer the questions that I ask you directly and concisely. If there is something that you would like to explain, you can do so later during the recross. Agreed? Agreed. You said in your first report that you have 30 years experience as a lawyer. A little over 30. 32, actually. Okay, yes, you wrote that 2 years ago. Yes, I understand. Okay, 32 years. And 17 out of those 32 years you spent in the Rodrigo law firm, which is the Peruvian law firm that represents Freeport and Cervera, correct? Correct. So half of your career you spent in the Rodrigo law firm, right? Well, so far, but I'm going to practice my profession for much longer, I hope. Yes, of course. You were the partner of the Rodrigo law firm 13 years out of those 17 years, correct? Correct. Apart from being a partner, you were a member of the board of the Rodrigo law firm. Yes, for 2 years I was a member, yes. And during those 2 years, Luis Carlos Rodrigo was also a member of the board of that law firm, correct? Yes, correct. What you told me at the Cerro Verde hearing, well, on the basis of that, I understand that the board looks at general issues related to the law firm, the path the law firm is going to take, and strategic changes that must be made for the functioning of the law firm, correct? Correct. How many members on the board? 6. Going back to your practice at the Rodrigo law firm, at the other hearing, you said that while you were working in it, you provided advice to foreign companies, including mining companies, in connection with regulatory matters for investments and also stability matters, correct? Yes, correct. And you confirmed that you represented 10 or 15 mining companies, correct? Correct. I don't remember the exact number, ma'am. Yes, of course, but around 10 or 15, right? Yes, yes. Do you recall the names of some of the companies you provided advice to? Yes. Altamina, Noranda, Tech, Hadbay, Goldfield, Min Sur, Southern Peru. Yes, just about. At the last hearing, you said that you also provided advice to Milpo. Yes, Milpo. I dealt with some issues related to Milpo. A moment ago, you mentioned Milpo, and for the record, I would like to say that the Milpo agreements that you cited were in the file since their reply, but in your second report, you did not mention those agreements, correct? Correct. When did you see these Milpo agreements for the first time? Well, on the occasion of the resolutions that were added, and I had to look at the source, which were the stability agreements, to see each one of them. So when you provided advice to Milpo, you never saw the stability agreements when you were at the Rodrigo law firm? No. There was a very important extrajudicial transaction amongst the main shareholders of this company. This, the case was, it was 2 companies, and those companies split. But I looked at those issues, but not stability issues in that case. Okay. And the Milpo resolutions, when did you see them for the first time? Well, perhaps 2 weeks or 1 week before the Sumitomo hearing. The Sumitomo hearing? Yes, the first hearing. Okay. At that hearing, in February, you said a month ago. Well, yes, at February, mid-February, so maybe it was that happened 10 days or 15 days before the hearing. Cerro Verde Council did not show that to you before? No. Cerro Verde was also a client of the Rodrigo law firm when you were a partner of the law firm, correct? Yes. During the Cerro Verde hearing, you confirmed as well that you were one of the individuals that had knowledge of stability matters in the Rodrigo law firm, correct? Yes. And that is why you were asked to participate in meetings with clients. Yes, on some occasions, yes. I wasn't the only one. There were other experts as well. How many experts were there on stability matters? As far as I can recall, 3. Mr. Rodrigo and Mr. Jack Batias. Regretfully, he's no longer with the firm. As you indicated in your report, and you said also at the Cerro Verde hearing, it is possible that you participated in a meeting that was related to Cerro Verde, right? I don't recall a meeting like that. I looked at stability matters, and I was asked to participate. It is possible that happened. This happened many, many years ago. It is possible that I participated at a meeting, but I do not remember the client. I do not recall, but I cannot emphatically say no. In your report, you say that you were not a member of the main team, but again, you were one of the 3 experts of the Rodrigo law firm in stability matters. Yes, it is possible that you were asked to participate in 1 or more meetings. It's okay that you don't recall, but it's possible, correct? I do not recall. I do not recall being asked to participate in meetings. The Rodrigo law firm provided advice to Cerro Verde when the 2002 pre-feasibility study was being prepared, right? And Cerro Verde was analyzing that stability agreement. I don't recall. When did you leave the Rodrigo law firm? In 2011. It's okay if you don't recall, but I represent to you that Rodrigo law firm provided advice to Phelps Dodge and Cerro Verde in the application of the Provider Investment Program in 2004. Yes, I saw that on the record, but I don't remember the date exactly. But now, when I saw it, yes, of course, starting in 2004, it was a client of the law firm. So you remember 2004, but not 2002. I don't recall, but it's possible. It's possible that it was a client in 2002 because it was part of the same proceedings. Then in 2005, you provided advice, and in 2004, you provided advice to Phelps Dodge and Cerro Verde in the structuring of the financing for the concentrator. Yes. I've seen that. In your first report, you indicate that in 1990, you had a stage in southern Peru for about a year. Yes. Southern Peru, that was later a client of Rodrigo, the Rodrigo law firm. Yes, at the time it was also the client of the Rodrigo law firm. Since 1990, right? It started being a client in 1990? Yes. When you were doing this, Mr. Hans Fleury was the legal vice president of the company, correct? Yes. And from your testimony in February, you got to know him from that time. Yes, when I was a stagiaire in Southern. And there you said that you saw the mining units, Toquepala, and he visited those on occasion. I worked at the legal department of one of the mining units. Southern at that time had 3 mining units, and I worked in Toquepala. There was the southern area, and we looked at the legal matters of all the 3 units, and Mr. Hans Fleury was a legal vice president of the whole company, and he traveled periodically to each one of the units. So obviously he was an important person. When he came in, everybody knew, and everybody knew who he was. Hans Fleury, at the time, was one of the directors of the National Mining Society. I do not recall, but 2 years later, I remember that he was a director, but because he was the one who entrusted things to me by the minister. Okay, yeah, we're going to deal with that. Looking at your CV and your first report, you say that you graduated as a lawyer in 1989, and then you obtained your degree in 91, correct? Yes, in 1989, I obtained my degree in law. First, in Peru, when you ended your studies, you had to submit a thesis to a jury, and then you obtained your basic law degree. After that, you had to obtain your lawyer degree, where you had to you had to support and present 2 files before a tribunal. The legal cultures are different. So just to understand, law studies in Peru are pre-grade studies, right? Yes, that's right. 7 years is the full field of studies. So the 7 years ended in 89 or 91? 88, because I took a year to prepare my thesis. My thesis was a 2-volume thesis, and, I took a year to do it. So when you obtained your degree as a lawyer, your first degree as a lawyer, this is the year that you were entrusted the preparation of the TUO of the mining law, right? And this is done through the MINEM and through the National Mining Society. Yes, the 2O was entrusted to me after 92, because before 91 I was working on legislative reforms that happened during the process of reforms to promote investments.
Perdón, solo para aclarar.
Just to clarify, in your resume, let us look at it on the screen. This is Exhibit C. Unfortunately, I do not have the page number. It's B, rather. Exhibit B, second page. Your first experience is right there from 91 to 92, and you're referring to participating in various reforms, and there you see the text of the mining law, correct? Yes. The reforms, yes. As a consequence of having worked on the reform, I was asked to systematize the single consolidated text, and then I also worked on the TPA text, and I was also participating in the negotiation for the sign of this agreement. That was the experience that I had for that year when I was asked to work on the single text of the mining law. In your report, unfortunately, I do not have the paragraph here. It says that you were asked to participate in 1991. Is this a correction? No, I was not called to participate in 1991. It was in 92. The text is of 92. The law is of 91, but the single text, due to the modifications to the 91 law, were introduced in 92. I was asked to do this work, and I finished it in June 92. And up to that moment, up to 91, based on what we see in your resume, your only professional experience had been the southern internship. Well, I had my studies, the practice, and I also worked at a law firm with many mining clients. Then I worked on auditing. Let me interrupt you. I asked you during the Cerro Verde hearing whether your only experience when you were consolidating the mining law in the mining sector had been the Southern Peru internship, and you answered correct. Are you changing that answer? No. It's okay, but in addition, all of this was prior to that internship when you were studying law. Yes, during my 7-year course of studies. Now, as part of the process to consolidate the mining law, you did not meet with the people who were in charge of drafting the Decree 708. No, I did not, because I was asked by the Minister of Mines, of Energy and Mines, to work with the institutional support of the officials who were in charge of the ministry at that point in time. So any doubt, any concern, I had to talk directly to the Vice Minister. He was the one that I talked to the most, but I also had the public Minister of Mining from the public side, and I also had the support of the mining sector and all of the lawyers who had participated in the previous law, but also throughout the reform process. In the Cerro Verde hearing, you said that it was not relevant, in your opinion, to have met those who were responsible for drafting the legislative decree 708 to understand the meaning of those reforms that had been enacted a year before. It wasn't relevant. It wasn't necessary. I had the support of the ministry, and the minister himself told me, any doubt you may have, talk to those who are in charge of the ministry. So that's why I didn't think it was necessary to resort to these individuals, to the minister, because I didn't know that Mr. Polo had participated in this process. You didn't know? No. You didn't ask the vice minister? No, I didn't. You didn't ask the minister? No, I was told about the previous minister, and I also worked on the reforms that in parallel occurred with the mining reforms. Sometimes we had meetings in adjacent rooms, so I knew who were in charge, but I never saw anyone else. I didn't know who he was, and now in this arbitration I have heard that he was part of that reform. And that, to better understand, the only one that knew that had participated was Mr. Sanchez Alvavera, correct? I didn't hear before. I don't know if he was the only one, but at least when I was there, I didn't hear. And you only heard about Mr. Sanchez Alvavera. I didn't hear, but I knew because I was reading all of the standards. I knew who the ministers were. I was working on the reform. I attended the Council of Ministers, the preparatory meetings, and several meetings with all of the ministers. It was very active. So I knew who the ministers were, and I was working on the other, while I was working on the other reforms that were in 1991. And now you're telling me that it wasn't necessary to meet with them. You didn't think it was relevant. Are you changing your testimony? No. But we need to see what is in the law. And any doubt I may have had was to be clarified with those who were in charge of the ministry, those who had the institutional position of the ministry. Now, to draft the single consolidated text of the mining law, this process is not innovative, or it is not an interpretation, correct? In this specific case, I think it was. At the Cerro Verde hearing, your answer to the question was correct. That's why it is called single consolidated text. Are you changing your answer?
Transcript, please. Of course. Can we show the expert the relevant transcript?
Si va a la pestaña 3, por favor.
If you look at tab 3, and we can show this on the screen, here you see page 2169 in Spanish. Line 5, that's my question, that reads, and the preparation of this text in Peru does not entail interpretation, correct? Are you changing? No, I am not, but I thank you because now I have the opportunity to clarify that your question was of a general nature. You're asking me about the single text of administrative procedures. So the mining text was a special situation because those laws or rules had a difference of 10 years in between. Some aspects of the previous law were eliminated, some concepts did not exist, some tasks were not carried out by the state anymore. It was not cutting and pasting. We had to understand whether there had been implicit abrogations, because even though there had been some explicit abrogations, others were up in the air. So we needed to work carefully, and we also had to be careful and have experience in this type of legislation, and this is what I had been doing over the last year. So that's why I think that the single consolidated texts do not have an innovative nature, but in this case it was innovative because we had to adapt, and also this required a deeper analysis beyond systematizing or consolidating. So as to your question, I am not changing my statement. I am just being specific. In this case, the single consolidated text, in my opinion, was innovative. So to better understand your answer, in general, the single consolidated texts in Peru are not innovative, and they do not have an interpretative nature. No. This is just to consolidate, correct? Yes. Well, it depends of what happened with the mining law, whether I can tell you if it is innovative or not. Interpretative, no. But we do need to look at the situation if it is innovative. For example, in the case of the mining law, I am explaining why I think that it was an innovation and it entailed interpretation. And in your testimony, the mining law, which I understand was an exceptional case, different from general cases of the single consolidated text, your testimony today is that it was innovative, correct? Yes, it was innovative as of the systematization work that had to be done from the legal standpoint. I am not saying that things were changed as provided in the laws, just that clarification. So you cannot draft new rules. I cannot modify anything. So you cannot modify the two legislative decrees that were consolidated under one document. I cannot modify, but if there are some provisions that as a consequence of the amendments or changes need to adapt to the new terminology and concepts, the work has to be done. That's why they look for someone who had experience, otherwise the lawyer cannot establish that difference, and so that we do not cross the border between an adaptation and a modification, we need to consolidate everything under the rules so that the administration and the mining companies can have the certainty as to what the legal framework is. I don't know if this is clear enough. And your statement is that that innovative work was assigned to a person who had just graduated. Yes, but I had been working on the production of rules and systematization of rules and regulations 24/7. I had been working on that for a year and a half, and honestly, if they chose me, it was because there was a reason. And your statement is that the innovative task was done without consulting anyone. You did not consult any of the individuals who issued decrees 109 or 708. No, 109, of course. I told you that I had the institutional support of the ministry. I had several meetings with the vice minister, the minister, and some directors from the Ministry of Mining and from the private sector. I consulted those that had the most experience, and one of the witnesses for Peru was Mr. Alfonso Rubio. Alfonso Rubio had participated in the drafting of Legislative Decree 109 of 1981 and also in the new laws. And clearly, I had Hans Kruger, who was also an expert. Those who had the most knowledge, I had worked with them either because they had been my professors or I knew them through my practice, and I had direct contact with people from the ministry. So you're telling me that you consulted the private sector, the individuals that you just mentioned, but you didn't think it was relevant to consult those who drafted Legislative Decree 708. Is that what you're saying? What I am saying is that I consulted those who I needed to consult based on what I had to do. I am telling you that I consulted with these experts who had the most experience in explaining the general mining law, and as to the public issues, I consulted whenever I had to consult, whenever I had a doubt, the officials that were in charge of the ministry, who were leading the ministry. The second in charge, they are the ones who had the institutional position of the ministry, and what then was the practice in mining. And just to understand, during the Cerro Verde hearing, you told us that you do not have the contemporaneous notes of this task, I understand, based on you, of this innovative task when you consolidated the texts of 109 and 708. This was more than 30 years ago, and I do not have any notes. Did you look for them? Yes, I did. But I have not found any notes, and I don't remember taking notes because it was a highly specialized task, and neither the vice minister or the minister were lawyers. That's why they asked me. I was a lawyer, and we had periodic meetings, and they asked me, how are you doing? What progress have you made? Do you have any doubts? But I didn't have any notes saying I was asked to do this or that. Dr. Vega, you just told us two different things. No, I didn't. I'm sorry, I'm asking the question. You told us that either you didn't find notes or you said, I do not recall taking notes. So you were not taking notes? Is that what you're saying? I must have done it on the text itself. It wasn't so digitalized back then, but since it wasn't digitized back then, so I don't recall. I tried to find them. Since I don't recall, I tried to find them, but I couldn't. So in your report, you are referring to several articles on the legal stability agreements in Peru, and you are referring to that at Exhibit B in your resume, correct? Yes. And if we look at B in your report, you only include two publications, but you do not include any related to the stability agreements under the mining law, correct? Correct. And at the February hearing, you told us that you have not written chapters or articles specifically on stability agreements, correct? I have addressed them as part of the studies on stability in general, and also legal stability agreements, then the general system, and then I was talking about the mining system because I was focusing on that sector, but I have not written specifically on the mining stability. You also told us that you were never a professor in Peru. Yes, I am not. I do not have a master's degree, and that's one of the requirements to be a professor. But I also said that I did attend several classes, that I had been invited to teach specific classes on my experience in the area of stability and also the negotiation of the treaties for the promotion and encouragement of investments on behalf of Peru. Just to confirm, at paragraph 13 of your first report, you say that you're being paid or that you are charging $320 an hour. Do you confirm this information? Yes. Thank you.
Time, and I'm about to go into a different line of questioning, so I don't know if we want to take the break now.
Yes, please.
Okay.
So 15 minutes of break. Can we continue?
Yes. Thank you, Madam President.
Ms. Vega. Now, getting into the substantive issues. Before getting into it, I'd like to understand your position on the scope of stability agreements. In your report, you established, and you said so a moment ago in your presentation, that stability guarantees, which are specifically provided for in the law, extended broadly to all investments that a mining company would make over a 10 or 15-year period within the concessions or mining units included within the stability agreement. Is that right? Correct. So in your understanding of the law, any type of investment made during the contractual period, even if not contemplated, even when the agreement was signed, would be covered, right? If it is done within the concessions that are part of the mining unit that's been stabilized, then yes. And so your position is the investment, in order to be covered, has to be made within certain concessions. They can't be investments in just any concession that the company has. They have to be within the concessions that constitute the mining unit and that are spelled out in Annex 1 of the Stability Agreement. And just to understand, that would apply going forward, but it also applies retroactively according to your position, correct? It's not retroactively, but rather it also includes, obviously, all of the facilities, investments made previously, but they're applied as of the coming into effect of stability. So it's comprehensive more than retroactive. If a company has been operating, say, for 60 years, and during those 60 years it has a leaching plant, and in the year 61 it signs a stability agreement for a concentrator with a feasibility study that includes only the concentrator, and that concentrator is built within the geographic area of the same beneficiation concession of the leaching plant, then your position is that automatically all of the operations of the leaching plant would also be covered for 15 years. Is that right? Correct. Insofar as it is on or within one of the concessions in the stability agreement, then yes, that's the spirit of the law and it's reflected in the law. Once a stability agreement is signed, all of the investments made within the concessions or mining units provided for in the agreement enjoy stability. In other words, that leaching plant, which had been operating and which produced hundreds of thousands of metric tons, with an investment, if just the minimum investment required is made, which is $50 million for an expansion, if a $50 million investment is made, then automatically everything from the past, that is to say the output of the existing plant plus any additional investment made for 15 years would be stabilized. That's your position? Yes, insofar as it's in the concessions or mining units covered by the agreement, then yes, and that's what happened in all the privatization processes. I would ask you to please limit your answers to the questions. Fine. I just want to note that that is, in fact, what happened, and that was the spirit of privatizing the state-owned companies, which had been so inefficient, which had not received investment. And the incentive is precisely for the previous and the new facilities and the new investments, insofar as they're done through the concessions covered by the agreement, are stabilized. That's what happened with several mining companies that were privatized, of course. And your position is that, for example, in the case of the 10 years, if one invests just $2 million for 10 years, then it's stabilized for the prior and future operations, the ones that were not known about, all of them, insofar as they're done on the or within the concessions covered in the contract, yes. And that is what happened in the case of Cerro Verde previously, its first stability agreement from 1994. It undertook a specific investment project to qualify. The project entailed a small investment to buy 2 caterpillars and a conveyor belt, and with that, it stabilized its mining unit and didn't have any problem applying the stability agreement as long as it was in force. Now, if we could turn to tab 5, please. And there you find the book by Minister Sanchez Albavera, who you decided not to consult, where he speaks of the mining reforms that were carried out in 1991. And just for the record, we have printed out an excerpt, but the full book is in the record. The book is called The Cards on the Table. And I understand that you're familiar with it because you cited it in your report, correct? Yes, that's right. And if we turn to page 81, please. Just to put this in context, this chapter addresses the mining reform, and Minister Sanchez Albavera, it's up on the screen, explains that the granting of these guarantees, he's talking about stability guarantees, constitutes an important incentive for mining companies by not altering the criteria that guided investment decisions, since their recovery is long-term, correct? Yes. And he then notes that the mining reform considers that stability contracts, or considers them for 2 types of investment. One, the new investments, you can see that in the next sentence. And second, those made by existing companies, which are like expansions, right? Yes, but that's for the purposes of requirements for qualifying, in effect. We'll see that in a moment. Okay. But just to make it clear, Minister Sanchez Albavera, what he says is that these contracts were applicable to 2 types of investments, new investments and also expansions made by existing companies, correct? Once again, I can tell you that that is a distinction for in terms of the requirements, but not for the stability agreements. And as we'll see, this concept was set forth in Articles 82 and 83 of the General Law on Mining, correct? It mentions the requirements in the case of new investments or expansions, as the case may be. It's one amount for the one situation and another for the other. If we now turn to Article 82 of the General Law on Mining, and the law is at tab 8. If you want to take a look at it, we'll put it up on the screen. In your presentation, you read out Article 82, underscoring certain or underlining certain parts of it, but let's see what you did not underline. In particular, Article 82 says, as you indicated, that the purpose was to promote investment and facilitate the financing of mining projects, correct? Yes, that's right. And you speak of 2 types of mining projects. One, with an initial capacity of not less than 5,000 metric tons, or second, it says, or expansions intended to reach a capacity of not less than 5,000 metric tons, referring to 1 or more economic administrative units, correct? That is what it says as a requirement for being able to sign the agreements. So your testimony is that that is just the requirement for accessing the agreement. But as we see in the article, in the part that you did not underline in your presentation, it speaks of two types of mining projects. One, the new investments, which are those that were being addressed by Minister Sanchez Alvavera, that is to say companies that are just starting and that make a new investment, and they need to, which need to, as a minimum, come to 5,000 metric tons, or a second type of project, expansions, which also have to be designed to reach at least 5,000 metric tons, right? Together, it's an expansion and then all of the mining unit, all of the production unit. Exactly. Now, this concept of two types of investments, or which is to say new investments or expansions, is also established in the next sentence in Article 82, which you do not underscore either. There it says, that stability contracts will be guaranteed through an agreement entered into with the state for a term of 15 years, and those 15 years are counted from the fiscal year in which the investment or expansion is carried out. This is number one, or, well, in which the investment is made, or the expansion. Again, it's two types of projects, right? Yes, once one has shown that one meets this requirement, then, and that the mining authority approves it, then it's just then that these stability agreements come into force. So these are requirements for being able to sign a stability agreement. The 15 years begin to run once the investment is carried out. In other words, a new investment to start up operations or an investment to expand operations. And there it says, as the case may be. Correct? Yes or no, please? That one show, not that it be done, but rather that it be shown to the mining authority, which is different. So if you are showing that the investment has been made, it's because it's being completed, correct? Yes, I just wanted to note that detail. Of course. Now, this article does not say textually that the stability guarantee is granted to all investments or all existing operations or all investments, present, future, known, or unknown, correct? Now, you're telling me with respect to the requirement includes all the foregoing. That's what it says first, that they must attain this capacity. In the second paragraph, where it speaks of scope, it's defining what is understood as the scope of stability, which is this set of mining concessions which constitute a single mining concessions, beneficiation concessions, assets, which all together constitute a single unit of production. It's the whole production unit with what's already there and the new parts that are to be brought in. That's what's once it's qualified and included as an annex to the stability agreement, it includes everything that is there and the new things to be done as well. That's the incentive for the granting of stability, so that the investor can have peace of mind knowing that my entire integrated operation is going to be stabilized, and that's how the mining industry works. Ms. Vega, I would ask that you limit your answers to my questions, please. The text does not expressly say what you've just told us, correct? Past, future, present, no, it does not speak of those time frames, but it does talk of all. Now, if you focus on the second paragraph there, where it speaks of economic administrative units, and if I understand your testimony, it's because a minimum level of production was required to be able to gain access to a stability agreement, correct? No, this second paragraph refers to the scope in general, and in this regard, it's in general for applying stability agreements. This second paragraph does not say that the application of the stability agreement, or it doesn't say that the guarantees contractually established apply to what you call the mining unit. That it does not expressly state that, correct? In that article it does not, yet it is an article of the law that is complemented by the three articles of the regulation that I've noted, and there's no doubt about it that all investments made within the concessions or economic administrative units that make up the production unit are stabilized. Ms. Vega, we'll get to the regulation in a moment. Let's continue. Article 83 also reflects this concept of projects with new investments or second expansion projects, correct? Once again, for purposes of qualifying, yes. For the purposes of determining the scope, as you can see in the fourth paragraph, it speaks of activities of the mining company in whose favor. It doesn't say anything specifically or the two cases you mentioned, so it is clear that the distinction that you are drawing applies only to the requirement for qualifying. In one case, the requirement of a minimal level of production, and in this case, the requirement of the minimum level of investment. That is where the distinction is drawn. In the fourth paragraph, which talks about the scope, doesn't draw such a distinction. We'll get to that fourth paragraph. Don't worry about it. Just to make it clear, in the first paragraph of 83, it speaks of this concept of the first type of investment, and that's why it had to draw up or have an investment program with for at least $20 million investment, correct? Yes. And if we are in the face of scenario 2, which is an expansion project, one needed to have an investment project of at least $50 million, correct? Correct, minimum, as you say. Of course, it could be more. Yes, obviously. The requirement had to do with meeting the limit that you had to match to get to stability. And at paragraph 29, what you are correcting in your paragraph 29 of your first report is that the requirements are minimum level of production and minimum amount of investment, correct? Yes, that's right. Now, if we look at Article 25 of the regulation, which is at tab 6. Excuse me, for the record, the exhibit number? Of course, I'm so sorry. It's CA 432. And the annex to the law is CA 448, I believe. Are you there? Yes, I am. This article, once again, speaks of both scenarios of investment projects. It says, without prejudice to the income and corporate assets tax returns which, according to the law, the mining activity title holder must submit in cases of, first, expansion, or second, expansion of facilities, or 2, new investments that contractually enjoy the guarantee of legal stability. Said title holder must make available to the tax administration the annexes that demonstrate the application of the tax regime granted to, first, the expansions, or second, the new investments. That's what the article says, correct? The thing is that article, if you look at when it was drafted, when it speaks of that contractually enjoy the guarantee of stability, the reference is that a stability agreement will already have been signed and that one is going to continue making new investments and new acquisitions, as is generally done in mining. And what this provision establishes is that that taxpayer, the mining company, must keep the demonstrative annexes, their working papers, so that tomorrow or later on, if there is an audit or inspection, they'll be able to show how they've been applying their stability. But this makes most sense when the mining companies have several mining units. So the meaning is that investments will continue, and if tomorrow there's a SUNAT audit and they ask me, I'll be able to tell them, well, as in the case of Milpo, for the Porvenir unit, these are my working documents that show you how I have been applying the tax regime to this unit. These are my working documents that show how I have been applying the stability guarantees to these new acquisitions I've made. That's the gist of Article 25. Ms. Vega, you do not mention Article 25 in your report, is that correct? No, because it doesn't refer to scope. Now, Article 25 does not speak of mining units or economic administrative units or concessions, correct? That article does not talk about that. It's talking about what I just explained. Of course, it speaks of once the agreement has been signed, what has to be done, and it reflects the two concepts of two types of projects that Minister Sanchez Alvavera mentions and which you don't mention, and that are addressed in Articles 82 and 83. Is that not correct? No, no. I'm explaining that this is not 82 and 83, which are requirements for signing the agreement. Here we're saying that the agreement's already in force with stability. Let's think about Milpo. It's fiscal year 2010 that they undertook the audit. It had 2 mining units, each with its own stability agreement, and each one had a stabilized regime. What this provision says is, Milpo, keep your demonstrative documents, because tomorrow if I'm going to perform an audit, you need to show me how you have applied to each of the units, each of the investments, and what you have done. It doesn't have to say so with first name and last name, but that is the gist of the provision. I understand that that's your position, but just so that it's clear, the article says that the mining title holder must submit first in cases of expansion or in new investments. And the concept of an expansion project or a new investment is a concept that was already indicated in Articles 82 and 83. Is that not correct? Ma'am, I'm explaining to you that that is not what this article is referring to. This article is referring to something else. It does not refer to what those articles refer to, which is the pre-qualifying stage to be able to access stability. This refers to the operational aspect. I don't know if I'm being clear. Ms. Vega, the regulation does not say either expressly that the guarantees granted contractually apply to all of the investments, all past operations, all investments, known or unknown, present or future. Correct? No, the law cannot say that in any country. It cannot talk about present, future, past. I don't think so. But it does say broadly to investments without establishing any restriction, broadly, investments made in concessions or mining units. What does that mean? All investments made in the concessions or economic administrative units that are provided for in the respective stability agreements. Now we're going to turn to Article 83, paragraph 4, as I promised we would. Thank you.
Luego de que
We just saw 2 paragraphs that talk about the idea of projects, new investments to begin operations or expansion projects. If we look at paragraph 4, it says that an investment program needs to be prepared for those projects. I'm sorry, that's the other paragraph. Paragraph 4, like you said in your report, in your presentation, it says the effect of the contractual benefits will have to do with the activities of the mining company in favor of which the investment is made. Yes, that's right. In your second report at paragraph 8, you say, is it here? Yes, it's behind tab 2. Oh, okay, tab 2. You say that this language cannot be read by omitting mining company. So you cannot read it. It will only fall on activities because the words empresa minera would be superfluous. Mining company. Yes, it refers to activities of the mining company exclusively. And that is what it says in that paragraph. But Ms. Vega, line 4 of the article does not say, well, let's see. When it says that it refers exclusively to mining activities, you're trying to draw a difference, and that in the sense that these can only be the mining activity companies of the company. Yes, of a mining company. Okay. A mining company can have multiple concessions, correct? Yes, multiple concessions, that's right. For example, some may be operational, some may not be operational. Yes, some may be at the exploitation stage, or others at the exploration stage, correct? Yes. When you read 83.4, you're only drawing a difference between the mining activities and the non-mining activities, correct? Ma'am, you know that the activities in Peru are governed by the system of concessions. Mining activities, that is. Okay, your position is that stability agreements, well, you're actually limiting this a little bit. You were saying that they apply to concessions where the investment is made, correct? Not all of the concessions that the company may have that are either operational or non-operational. Yes, in favor of which the investment is made, included in the stability agreement, and they're included there. That set of concessions that are a single unit of production and are included while the contract in force are governed by the stability regime. Ms. Vega, I'm confused. Let's see if I can clarify, ma'am. You have just told me that you were talking about the activities related to the investment made. Is that your position? Because, no, I'm talking about the activities of the mining company. Very well. The activities of the mining company. As we said, the mining company, as we said, may have a concession in the exploration stage, another one in the exploitation stage, a concession that is a beneficiation concession, and perhaps the stabilized investment applies just to one of them, correct? The one that's going to qualify for the purposes of stability. It says here, specifically in connection with the mining activities. What mining activity? The one that receives the qualified investment. Okay, the activity that receives the qualified investment. No, the mining company that receives the qualified investment has met the requirements of minimum amount of investment, etc., as established by the law. That's a confusion, ma'am. The company that receives the investment operates a number of concessions around the country in different geographical areas. For example, one in Arequipa, one in Piura. Which ones are included in the stability agreement in your supposition? Okay, Piura. And they have to do with the production unit. No, we're talking about the concessions in Piura. Are they mentioned in Exhibit 1 or not? Yes, they're mentioned in Annex 1. Your interpretation of Article 83.4 that distinguishes only between mining and non-mining activities would cover, according to your position, it would cover both Piura and Arequipa. No, that's not your position. No, I'm trying to explain. My position is that the investments made in the concessions included in the production unit submitted to the ministry, and the ministry has qualified for the purpose of the signature of the stability agreements, those are included. That is my position. Can we show, please, 83.4 again? Where is it that you see in this article, well, where do you see that additional limitation that you say exists in this paragraph? According to your testimony, it only talks about mining activities and not other activities, not a restaurant, for example, not a building. These are two different things. Activities of the mining company. I'm trying to explain to you the origin of this article. The origin of this article has to do with mining matters and the company that must receive the investment directly. I was explaining that this came from the practice that the state had in the past of having conglomerates, state-owned conglomerates, and oftentimes a company making investment in one area could extend it to other areas. First, mining activities need to be made clear here, and then these companies are the ones that receive the investment. It doesn't extend to others. Perhaps it is clearer in other cases, such as mining holdings. At paragraph 4, it does not say that it applies to the concession where the investment is made, only to that concession and not others in other places in the country of that same mining company that, according to you, receives the investment, right? I didn't understand your question. Please repeat it. Of course. Paragraph 4 does not provide any limitation to the application of the stability agreement, as you say, to the concession in which the investment is made, and it doesn't apply to the other concessions of that same mining company that receives the investment, right? Exclusively to the activities of the mining company. Okay, that mining company, ma'am, has multiple mining activities in Piura, in Arequipa. I don't know where else in Peru we can have mining activities. I'm not a local in Peru, but my apologies. But if it makes an investment in Piura for its concessions in Piura, to be clear, your position is that it applies to the concessions in Piura, but not to the concessions in Arequipa. Yes, obviously, because the production unit that receives the stability and the one that is guaranteed is that one. Okay, but that is not what this article says, because in your understanding, it talks about mining activities in general, and that same company has, the same company that receives the investment has mining activities in Piura and in Arequipa and elsewhere in Peru where it can have mining activities. Your position is that somehow the article limits this to the Piura concession only. Is that your testimony? Yes, the concession in Piura that receives the investment, yes. You are saying, well, before I get into that, at paragraph 41 of your first report, and then just a contextual like this, at paragraph 40, you're explaining what you just told us in connection with 83.4. And then at paragraph 41, you say Articles 72, 80, and 84 also defined stability guarantees by making reference to the mining activity title holder. In other words, the mining activity title holder with operations in a mining or beneficiation concession. That's what it says, right? Yes. Just to understand your position. Your position is not that the stability applies to the whole company. No, it does not apply to the whole company. It applies to the concessions that make up its mining units. In the case of Milpo, there are a number of units and in connection with El Porvenir or Cerro Lindo. In the case of Cerro Verde has only one mining unit, so it was the whole mining unit. But it depends on the case, right? It depends on the company. Right. But in the paragraphs you're citing here, you're just saying that they refer to the mining activity title holder, the company. Well, the mining activity title holder is the taxpayer. It is the title holder that holds the concessions, but that does not mean that it is the one that receives the mining stability. This issue of mining activities, in your presentation, you said that mining activity in general is regulated, correct? Yes. And there are certain types of activities, exploration, exploitation, beneficiation, amongst others, right? That's correct. To conduct those activities, to carry them out for exploration purposes or exploitation purposes, one needs a concession, a mining concession or a beneficiation concession, correct? Yes, for mining purposes, mining concession. For processing, beneficiation concession. And those concessions under the mining law are rights that one has to get to obtain, to carry out those activities. Yes, it's a title you need to access those rights, but then, of course, you have to do certain things to keep them current. Apart from obtaining the concession, the title holder must obtain certain licenses, permits, environmental licenses, etc. Correct? Correct. It's not that automatically with the concession you can exploit the geographical area where the concession is in, correct? Correct. Once you obtain the concession, the title holder that wants to carry out one of these activities has to make investments to carry out these activities, correct? Investments to construct infrastructure and to carry out these activities. The investments are described in feasibility studies, for example, correct? Yes, the feasibility studies contain the initial investments that the title holder commits to making in order to have access to the stability. Well, and then the feasibility study describes the investment specifically, right? Yes, that's right. To qualify, it is a specific project. And the feasibility study do not describe a specific investment in a company, right? They describe the investment in a project, correct? Yes. Article 85 of the mining law establishes that for the 15-year contracts, one needs to submit a feasibility study, correct? Correct. This is a feasibility study. It's a technical economic feasibility study that is going to be an affidavit, and it needs to be approved by the DGM, correct? Yes. If we look at Article 24 of the regulations, it's going to be shown on the screen momentarily. Article 24 provides that the feasibility study will serve as the basis to determine the investments that are the subject matter of the agreement, correct? This article, please respond to my question. Yes, as you said, it is regulating Article 85, which is the requirement to have access to stability. Excuse me. Why don't you read the full article and you talk about this? It mentions Article 86 of the 2.0. It says here to determine the investments of the subject matter of the contract in order to proceed with the signing of the private deed prepared in accordance to the model approved pursuant to Article 86 of the Single Unified Text of the Mining Law. With the feasibility study, you determine the investments that are the subject matter of the agreement, and that contract is prepared on the basis of the model stability agreement that has been approved, right? Yes. For the stability agreement to be signed, what this provision says is that once the feasibility study has been approved and the study evidences that the requirement has been met, then you can proceed to the signature of the stability agreement. It does not say that it has been evidenced. It says that it will serve as the basis to determine the investments that are subject matter of the agreement. It doesn't say anything about evidencing the minimum requirement for investment. It says here will serve as a basis to determine the investments that are subject matter of the agreement. Well, in order to then proceed to the signing of the deed. Well, yes, once I have the directorial resolution, I can go to the ministry and say I can sign the contract on the basis of the investments that are provided and foreseen for qualification purposes. For purposes of proceeding to the signature of the contract under the model contract approved by the Supreme Decree in the case of the 15-year contracts. The article says that the feasibility study will determine the investments that are the subject matter of the agreement, and once those investments are determined, then you can sign the contract, right? Yes, you have to determine that those investments are the ones that qualified in order for the contract to be signed. Just to be clear, ma'am. Article 24 does not talk about qualifications to enter into the contract, right? You know that the feasibility study is what you need to qualify to sign a stability agreement. Well, you need to include a specific investment project for the purposes of meeting the requirement to sign a stability agreement. So then you can go ahead, sign the stability agreement, and then use the model as approved. In your presentation, you were asked about the reforms of 2019. The text of this article, it says here, which will serve as a basis to determine the investments subject matter of the agreement, that did not change, right? Article 24 changed, I think it was 39 later, I don't know. I would have to look at the text of the amendment. You're going to see that with your lawyers, I'm sure. In your first report, you talk about the feasibility studies. You focus about evidencing the minimum amount of the investment. I'm going to focus on paragraph 33. Let us show it on the screen. Halfway it says, rather, the feasibility studies played a specific role. They demonstrated that the mining company's qualifying investment program was technically and economically feasible and had to comply with the mining law's initial minimum investment requirement to receive stability guarantees, right? So, feasibility studies meet an objective, which is to determine whether an investment contained in the investment program is technically and economically feasible, right? If the project that is submitted is technically and economically feasible. Again, the feasibility study talks about a specific investment project, correct? Yes. Only in that case, it is a specific investment project to qualify and to sign the stability agreement. Article 19 of the regulations, let's put it on the screen, please. It's behind tab 6. CA 432 for the record. Article 19 establishes the requirements of what needs to be included in the feasibility studies as mentioned in Article 85 of the single consolidated text of the law. Correct? Correct. It's quite detailed. We're not going to look at it right now. There are a number of requirements. We don't have enough time. But if we look at B, it says that the feasibility study must include the acquisition of machinery and equipment to be used in the project. Correct? Yes, in that specific project, yes. Okay, in that specific investment project, right? Yes. And then, if we look at G, you must include the profitability of the project. We're talking about the specific investment project included in the feasibility study, correct? Yes. In your report, you cite an article of Antonio Pinilla Cisneros, correct? Yes. At the last hearing, I understand that you said that he is a lawyer working for a mining company, correct? Yes, in Altamira. Were you able to hear the statement by Mr. Bullard, who came after you, as to who Mr. Pinilla was? Yes, of course. I knew him from the university and from professional practice. Mr. Bullard said that he is an individual that knows a lot. He works for a mining company. I understand that he has been a professor, correct? Yes. If we look at tab 9, CA 114, where are you? Tab 9, please. Okay. What page? 177. This article, he is talking about the situation of royalties and why royalties should be included within the regime of administrative stability, etc. But there is another paragraph that I want you to read with me. After talking about Clause 10 of the stability agreements, it says, and it's being highlighted now, I don't think this paragraph has been translated in English. I'm going to read it so it can be translated in English. The explanation for the existence of this clause is simple. It's talking about Clause 10 here. The feasibility study developed and approved by the Minister of Energy and Mines contains the economic basis on which the mining project investment has been structured, correct? Yes, that's what it says. Okay, it contains the economic basis on which a specific investment is decided, right? Yes, because at that time is the only certain thing that a company has when initiating the project. Right, so it says for the preparation of this plan, of this feasibility study, investment program, a number of variables are taken into account, right? Amongst others, the legal regime that exists in the country, in the destination country of the investment, at the date of preparation and when it's been submitted for the approval of the administrative authority. The feasibility study analyzes the legal regime applicable to the investment and that is sought to be conducted. At the time, yes, but to conduct an analysis of something, the only certain thing to have access to in the stability agreement is the initial investment that you have to do and include in your feasibility study. That is what this is making reference to. I also consider that he is a very good lawyer. I cite in my report, Mr. Pinilla. Mr. Pinilla was talking about contratos ley. The stability agreement is a contrato ley, and I cited him in that context. I have read the whole article. I don't agree with some of the drafting of certain portions, but that is the explanation on which we need to understand the reference by Mr. Pinilla. If we read on, it says, the stability of this legal regime, he's talking about the legal regime, is a key factor for the determination of the destination of the investment. Again, a specific investment. The only thing left for the calculation of the return for investment is the activity submitted to a fluctuation of prices. So the feasibility study takes into account a legal regime specific at that point in time and specific for that investment that is being analyzed, that is being detailed in the feasibility study. As we saw in Article 19, as Mr. Pinilla says again, it calculates the return on investment on the basis of that legal regime applicable to that investment. Right. That is what the provision says, a specific investment so that we meet the requirement established by the law. The analysis has to do whether this project is economically viable or not in connection with the minimum amount of investment that it commits to make. Then it says, in other words, it eliminates the concern of the constant changes of the tax regime, and it eliminates the concern that the legal regime may be modified, that the investor took into account when projecting the investment, the specific investment contained in the stability project, right? What did you say? You said stability project? Is that what you said? It says, what stability does is it eliminates the concern of the constant changes in the tax regime, and it removes the concern that the legal regime may be, in and of itself, modified. The legal regime that the investor took into account when projecting the investment. The investment has been specifically established in the feasibility study, right? Yes, this is more of the same. It refers to the feasibility study containing the initial investment to qualify for a stabilization agreement. That is the initial investment. We know that perhaps there are other investments that are going to be made, but at that time, the analysis and projection is based on the investment included in the feasibility study. To be clear, the feasibility study does not include uncertain investments. It includes a specific investment being analyzed at that point in time, right? That is what's needed to qualify for stability. The project has to be economically and technically viable, and it has to meet the requirements set forth by the law. Thank you.
Thank you. Any questions in redirect?
Thank you, Madam President. Can we ask you for 3 minutes to reconvene?
Sure.
Thank you so much. Madam President, we have no further questions.
The tribunal has no further questions either, so thank you very much. You are released as an expert. Can we then right away continue with Mr. Boulard?
Yes, we just need to switch seats. You're fine? Okay, then we don't need to switch seats.
Can we then proceed with the claimant expert, Mr. Ola? So, welcome. You have been called by the claimant as expert in this proceeding. Let me just briefly introduce the tribunal. Maybe you know members already. On my left, I have Professor Tawil. On my right, I have Dr. Kremades. My name is Inka Hannefeld. I'm the presiding arbitrator in this case. If I could kindly ask you to read out the declaration in front of you.
Pardon?
I solemnly declare upon my honor and conscience that I shall speak the truth, and it will be, what I'll say will be in accordance with my sincere belief.
Thank you. We have 3 expert reports of yours on the record. It's CER 2, 7, and 12. Can you confirm that these are your reports, and do you have any corrections to make?
Sí, son mis reportes.
These are my reports, and I do not have any correction to make.
And I see.
Y vemos que usted realizará una presentación una vez más.
I see that you have prepared a presentation. We have the Spanish version in front of us, so please start with your presentation.
Okay. Muchas gracias.
Thank you very much. I will be summing up the content of my 3 reports in the time I have been allocated. This is a brief summary of my academic and professional experience. This is in the first report as an attachment. You can review it there, and I will be addressing directly the 4 topics. I will be addressing the legal framework of the Stability Agreement, interpretative analysis of the Stability Agreement, the Supreme Court decision in the 2008 royalty case, and the breach of the Stability Agreement. First, the Mining Stability Agreement, as it has been said several times and as it has already been recognized by experts and witnesses, is an adhesion contract as stated under Article 86 of the mining law that provides that they are adhesion contracts and their models will be prepared by the Ministry of Energy and Mines, and there is also a model contract that is, or agreement that is approved by a supreme decree. What does it mean to have an adhesion contract? First, it means that there is a unified and consolidated text and regulations that establish the conditions for the stability, the guarantees, and the scope. This is reflected in a model agreement that has to follow what the law states as well as the regulation. Therefore, the stability agreement, by being based on the model contract or agreement, has to reflect what that states and also what the mining law and its regulations establish. This is traceability. The stability contract can be traced back to the regulations and the law by means of the model contract. The idea is to guarantee that there is a perfect reflection of what the law states, what the regulations state, in the text of the stability contract. This means that a stability contract should have the legally established scope. It cannot have more or less. It has to have whatever the law provides for. Therefore, it cannot go against the law, the mining law and its regulations. It cannot be interpreted contrary to the mining law and its regulations. And a greater or lesser scope than the one established by the mining law, the regulations, and the model contract cannot be negotiated. The second comment, the interpretative analysis. If we interpret the stability agreement under the mining law and its regulations, the leaching project of Cerro Verde means the Cerro Verde mining unit, which is an administrative economic unit, and that means mining concession Cerro Verde 1, 2, 3, and also the beneficiation concession. This is the consequence of reading the law, the model contract, and also the stability contract all together. Let us look at the contract and the third clause. The third clause is known as on mining rights, and mining rights under Peruvian law means concessions. That is clearly established at the preliminary title in the text of the law. So we're talking about mining titles and concessions, and the third clause defines the scope of the contract. This clause uses the term is circumscribed according to what is expressed in 1.1 of the leaching project of Cerro Verde. This is circumscribed to the concessions related in Exhibit 1. And circumscribed means to limit, to restrict. One restricts, limits the scope of the leaching project for Cerro Verde, and that limit, that scope, is precisely what we see at Annex 1 or Exhibit 1. And that means that this is only limited, Cerro Verde contract is limited to Annex 1, Exhibit 1, that includes the Cerro Verde concession, the beneficiation plant. This word is not in the contract. Nowhere in the contract we see that, according to what is expressed in 1.1, the leaching project of Cerro Verde is circumscribed to the concessions. If it was for geographical purposes, the stability contract would have a different drafting. But here it says circumscribed, and the second paragraph also helps us understand the first one. What is provided in the above paragraph does not prevent the owner from incorporating other mining rights. And a mining right, as we saw, is a concession. We can include a concession, a mining right to an administrative economic unit, but not a mining right to a concession. And here it says other mining rights. You cannot include that to an investment. An investment is not a mining right. A project of investment is not a mining right. And here we have an administrative economic unit with beneficiation, and here we have to the right an investment project with a fleet of trucks or a plant. This is part of a beneficiation plant, but this is separate. There may be several plants or processes within the same beneficiation project. It is totally feasible that another mining right becomes part of the administrative economic unit under the second clause, but it is not feasible for a new concession to be part of an investment project. I cannot include a concession to a fleet of trucks or to facilities. I need to include it legally to a new mining right. So the second paragraph of this clause is telling us that the inclusion has to be to mining rights to allow for the stability of the new right. The reading of the stability contract is consistent with the mining law. Mining stability agreements grant rights to administrative economic units. And if we look at this Article 82, we see that in order to promote investment and facilitate the financing of mining projects referring to one or more economic administrative units, mining activity title holders shall enjoy tax stability that shall be guaranteed through an agreement entered into with the state. Here it doesn't refer to investment project, it's referring to the economic administrative unit. And if we look at the article, it says, this is the second paragraph, for the purposes of the stability agreement referred to in the preceding paragraph, the term economic administrative unit means the set of mining concessions located within limits set forth in Article 44 of this law. The processing plants and the other assets that constitute a single production unit due to sharing supply, administration, and services. An economic administrative unit is an economic operational concept. It is the one that is stabilized for the purpose of the contract. This is what we see here. If the interpretation was that this is only to stabilize investment projects, the second paragraph would not be consequential, it would not be useful because it would be good for nothing. And this article also creates a different concept of economic administrative unit, different from Article 44, because this is for the purpose of stability. The regulations also refer to concessions, but it never refers to investment projects. Here we see that when natural or legal persons are the title holders of several concessions or economic administrative units, the qualification will only take effect for those concessions or units that are supported by the stability agreement. Those concessions or units that are included there, so it doesn't refer there to the purpose of an investment, rather a unit or concession. And Article 22 has two paragraphs that have been discussed at length, and at first it says that contractual guarantees shall benefit the mining activity title holder exclusively for the investments that they make in the concessions or economic administrative units. So it goes back to the same concept, and the second paragraph clearly states why that concept is important: to determine the result of its operations. A mining activity title holder that has other concessions or economic administrative units shall keep independent accounts and reflect them in separate earnings statements. There is no reference to independent accounts or separate results of investments. The reference here is to economic administrative units or concessions. And now we look at the model contract. What do we see in the first clause of this contract? Here we see that concessions are the relevant element. They are part of an economic administrative unit. That is to say, those that are based on these economic administrative units. And now I would like to understand why it is, how this EAU is created and how this is still reflected in the current contract. If you look at this, the concept of economic administrative unit has been defined as the Cerro Verde leaching project, so there is a qualification. And now from the contract, they take the term, the concessions constituted on the economic administrative units, and that goes back to the contract, is the same as the Cerro Verde concession 1, 2, 3. So one takes the concept economic administrative unit from the model contract, takes that out and says which one is the economic administrative unit I will be placing there, and that includes Cerro Verde 1, 2, 3. And it says from now onwards the Cerro Verde leaching project. And also in the signed stability contract you see two items. There it says investments, colon Cerro Verde 1, 2, 3. And from now on the leaching project of Cerro Verde. So here it says that Cerro Verde will be 1, 2, 3. Part of that phrase, it clearly indicates that from now on this will be referring to that. The third clause of the model contract is consistent with the first clause. It reiterates that what is relevant for stability are the concessions that are part of the economic administrative unit. Let's see why. And it says, as stated in the project, and then you have the name as defined at clause 1.1, it is circumscribed to the economic administrative unit consisting of the concessions. So here, once again, what do? They take the concept of an economic administrative unit and they say, okay, the first clause already told us that it is the Cerro Verde leaching project, and they include that based on the Cerro Verde leaching project to be restricted, understood as restricted to, and there you include Annex 1. Annex 1, that is precisely the one defining the concessions or mining rights that are the purpose of the stability. And here it says, what is provided in the above paragraph does not prevent the owner from incorporating other mining rights to this project. The model contract clearly states that it is that what is relevant are the economic administrative units, and Cerro Verde's stability agreement is consistent with this model because Annex 1 defines the economic administrative unit, and that is the concept that is reflected in the model contract. This is just an example. We have seen this exhibit several times, you will see that many of these names do not have any consistency as to what they are. One could not say that they all define a project. For example, in the case of Centromin Peru, there are two. Centromin Peru is the holding of a set of companies, Mark Túneles, that is a place where there is a tunnel, refineries, and smelters. It is just a foundation. I don't even know what it is, but it is not a place. So Minsur is the name of the company that has several concessions. So truth be told, there is no consistency, but the law, what is important here, what is important to define is the annex. The annex is the one defining the scope. You may review all of these cases, but all of these cases will include Annex 1, and Annex 1 will be defining a set of concessions, and they are the ones to be stabilized under the current law. Now, what happens here is that under the discussion, in this case, Peru's position is pointing to two concepts, but they are confused. On the one hand, we have the key to open up the door to stability, and the other one is the concession. No one is going to say that the stability plan and the feasibility are not important, but here what is important is Annex 1, the one that defines the economic administrative unit, and then the requirements are met, and that leads to the concession. These are several clauses that have been cited to say no. What defines is the technical economic study, but if you read these clauses, and if the tribunal has any doubt, I will be happy to address this. All of these clauses do not define the scope, rather how the procedure is followed to get to the trigger investment, the element that triggers the investment for the protection, and this is key. This determines the scope of the third clause and also 1.1. And it is interesting, clauses 9 and 10 are relevant to understand also the scope of the stability agreement. They define the guarantees. It is important or interesting because we have had a great deal of discussion. We're talking about tax stability, but the stability of this contract goes beyond tax stability. There is stability, for example, to be able to export the mineral. If Peru change a rule to ban the export, that rule cannot change the contract. There are rules on exchange stability, rules on the applicability of the concessions. So all of those rules, if Peru's position was correct, would have to be analyzed separately based on the type of investment, and a decision would have to be made as to what can be exported and what cannot be exported. For example, if you think of the concentrates, that is, or dust, how would we know what part of that dust or powder could be exported? Or if I go to the Central Bank of Reserve, in case there is an exchange control, how can we determine what can be the amount in dollars that can be exported? So this goes beyond the tax rules, and it is very difficult to think that the system was so Kafkian in terms of all of these guarantees. Now I am going to move on to the decision of the Supreme Court in the royalty case. This decision is used to support the interpretation of the stability contract, but as I am going to say in one of my reports, this judgment is not useful to decide this. It is not res judicata. It is only res judicata in an administrative adjudicatory proceeding at the local level, not in a contract case, and also in particular regarding 2008 royalty. And one looks at this because what we discussed under this judgment was an administrative adjudicatory process. It does not decide a civil decision. It is not a civil decision under administrative law. And this also has a practical effect. The evidence in an administrative adjudicatory case is just limited to that case, to the administrative case. There are no witnesses on the implementation of the contract or the interpretation of the legal framework. There is no evidence that reflects the contemporaneous intent of the government as to the benefits of the stability. There is no document production phase. So there is none of the phases that we have here. We do not have 2 weeks of hearings, and we do not have memorials. And luckily, if I go before the Supreme Court, I have 5 minutes to prove a case. And when one has an administrative case proceeding, they are very focused on the administrative process.
This, second, the royalties decision is not a binding precedent. This has been recognized by all of Peru's experts. It was even said so by Professor Eguiguren at the previous hearing. What the Supreme Court said about the 2008 royalties is not binding precedent. He clearly stated this. Third, the decision in the royalties case does not deserve any special reference either. Does not deserve deference either. Different judges can and often do reach different decisions. Mr. Eguiguren also agrees with me. He indicated at the previous hearing it could happen that there were different decisions because both the Superior Court and the Supreme Court were different chambers. But it could have happened that they would have been different because the courts were different, and there is where the role of the judge to interpret and motivate their vote comes in. And they might say different things. And they do say different things all the time. But moreover, the judgment has a conceptual problem. It's mistaken, legally speaking. This is a graphic that shows how the stabilization mechanism works. First, one applies for stability. With what? With a feasibility study. This feasibility study, once approved, makes it possible to sign the stability agreement. And once it's signed, it's possible to carry out the investment and finally obtain stability, to use the key to open the door and get into the house, which is the stabilized economic administrative unit. Now, be careful. It's very important to note that this is not exactly what happens here because it was executed before the signing of the agreement. But for practical purposes, it's not important. It's important to realize, I've often heard it said that the feasibility study is part of the agreement. The feasibility study is not part of the agreement. There's no annex to the feasibility study. The only thing there is a summary of the investment plan because, well, of course, in the agreement, one states what must be done to achieve stability, and to do so, one must make the investments that are defined in the annex, which is a part of it, but it doesn't define the scope of stability, which is the key to open the door. Actually, the problem of the court is that it is seeing everything as though it's a single color, but in actuality there are 2 different distinct stages. There's a stage where the feasibility study and the investment program are necessary to make sure that the benefit or the commitment of the investment be carried out. And then there is a stage where the state performs by according stability to the economic administrative unit. With this, I move on to the last point, which is the breach of the stability agreement. When is there a breach of contract? Let's recall, we're talking about breach of contract. The general rule is when there is when the debtor's conduct fails to deliver what is promised, and the obligation is breached when the application when different laws are applied than those that are provided for in the stabilized regime. That is where there's a breach. The obligation of stability that the state assumes an obligation to not apply a given regime to a stabilized regime or other than the stabilized regime. And every time Cerro Verde carries out an enforceable act, then there is a breach because that is where a law is being broken, one that is different from the stabilized one. This occurs in the different provisions under Article 115 of the Tax Code. There's a decision, for example, by the Tax Tribunal, which is final. The taxpayer does not challenge or appeal, which makes it a final decision, or the taxpayer withdraws its challenge or appeal, with which it is a definitive final decision. And from there, it's enforceable, this according to the Tax Code. So, only from the moment that there is a final and definitive assessment is there effective application of provisions other than those that are provided for in the stabilized regime. And at that point, Peru breaches its obligation with the final definitive and enforceable decision, and it is only at that point that Cerro Verde suffers a negative impact on its a negative economic impact, damages. So Peru is responsible for its a breach at that time, once it becomes definitive and enforceable, Cerro Verde has an interest in taking action because the action has the damage has been incurred, and that is where the statute of limitation begins to run. This is now in the Ponderosa case that the statute of limitations argument was raised, saying that the claim had prescribed. But to analyze whether the prescription has been triggered, it's necessary to identify, the court says, as from which moment Ponderosa had an expedited right to claim before the judiciary about the compliance with the tax stability agreement entered into with the Peruvian state. That is the question asked by the court. And how does it answer it? Well, in this case, as from the date on which the breach of the aforementioned agreement occurred through the issuance of the aforementioned administrative resolutions of the tax tribunal. In other words, it's just with the decision of the tax tribunal that it's understood that the limitations period began to run. Now, each assessment that becomes final, definitive, and enforceable constitutes, therefore, a breach. But moreover, each is a separate breach. Each is a distinct breach. Let us recall once again that we're talking about breach of contract. And let me cite an example. I have a lease contract, and someone fails to pay me for January. When they don't pay me for January, there's a breach. But that doesn't mean that they've breached in respect of February, March, April, May, or other months. They only breached in respect of January. Now, I cannot bring a claim for a breach in respect of February, March, April, May. I have no ability to do so. I don't know if there's going to be a breach. Imagine if this were variable revenue that depends on the sales of the company. One doesn't even know how much it is. So how can one bring an action unless there's a question of time frames and so forth? But if it is continuous and it's performed over time, then it's only when there's a breach in respect of February, March, April, May that one can then bring an action for those respective months. So if we were to carry this over to the stability agreement, it's only with the final decision that I'm able to bring a claim, and each one is different. They have different content, different times for application, different amounts, and therefore it's not possible to understand that the first implies a breach of everything that comes afterwards when we still don't know what has happened afterwards. With that, I conclude my presentation, and I'm available for any questions you may have.
Many thanks, Mr. Boulard, for your presentation. Before we continue with the cross-examination by the Respondents' Council, I may ask two questions to you. Now that relate more to your report than to the presentation, but just for me to better understand maybe also topics in cross-examination. In your first report, in paragraph 41, you state, when the government expanded the beneficiation concession to include the concentrator came formally under the protective scope of the stability agreement. Why, and this is my question, in your expert view, this is so under the Peruvian civil law rules on contract interpretation, taking into account that at the time that the stability agreement was concluded, the concentrator was not considered a feasible investment and was not included in the beneficiation concession at that time. And I heard you referring to this exhibit number 1, but this exhibit number 1 only refers to the old beneficiation concession, valid at the time. And this is quite significant in terms of the area and the production capacity named therein. So under Peruvian contract interpretation rules, why do I need to look at the beneficiation concession 8 years later?
Bueno, en primer lugar, porque como ya expliqué...
Well, first of all, as I already explained... Excuse me? Oh, I'm sorry. First of all, as I already explained, the key concept is that it is an adhesion contract. As it is an adhesion contract, the contract cannot move away from what the law says. The law defines stability as stability of the economic administrative unit or of a concession. So what is stabilized is Annex 1. That implies that any investment within the time provided for by the stability agreement is covered by the stability. This has always been my interpretation of the laws and regulations on stability, and that is what's happening in this case. The thing is that the concentrator was incorporated within a concession. That is to say, the concentrator is not a different concession from those that are already stabilized. They could have had a different concession, in which case, a different concession with a different project, in which case that concentrator, had it been invested in a concentrator other than the areas named in Annex 1, would not have been stabilized. But since it was incorporated into an already existing concession, moreover, that exists under the ministry's approval, plus the incorporation has also been approved by the ministry, by the DGM. So once it's incorporated like any other investment, such as purchase of trucks, such as the construction of a ramp, such as expansion of the already existing plant, because it's incorporated in the same concession. Now, what I think one must be very careful about is to not confuse the project for which the feasibility study is presented. One mustn't confuse it with the scope of stability. They're two different things. Now, this being the case, Peru has about 10 different stability regimes, and it works the same way in all of them. There's an investment, and that investment has to meet certain requirements based on what is offered. Once those requirements are complied with, then this stability is extended to a unit, sometimes a contract, sometimes to a company. It depends on the regime. In this case, it's a mining unit. But in every investment, that's not necessarily what is protected. There are some exceptions where an investor comes in from outside, where only the part that they contributed, their shares, are protected. But generally, with the oil stability, it's the same thing. There's a contract that's equivalent to a concession. One offers to drill 3 wells. You drill 3 wells, and then if you want to continue drilling more, all the other drilling is also stabilized. It's also protected under the same instrument. Same thing here. Now, you asked me about the criteria of interpretation, and here I think it's important to consider how the agreement should be interpreted. The agreement is a contract, the terms of which come from the law, so it's subject to a strict interpretation based on what the law says. Now, if the law sets forth a definition, the contract can't modify it. So the interpreter is limited. This doesn't mean you can only render a literal interpretation, but it means that any literal interpretation must not expand the scope. So my interpretation is that when you look at the text of the law, the concept of economic administrative unit is mentioned significantly in the relative articles. No mention is made in the relevant articles of an investment project. It's not to be found. The literal meaning of the clauses in the mining law, well, none of them would support the idea that what's been stabilized is an investment project, which is not even mentioned. So when one must stick to strictly to the text of the law, then one eventually reaches the conclusion that the interpretation of the agreement cannot depart from the law. This is in my report. I don't want to carry on further. But this is confirmed by a functional interpretation, which is another criterion allowed by the law, because the logic of it is to attract the investment and allow for the project to go forward. And in a systematic interpretation, what I mentioned, that not only is the text stabilized, but one must also see how this interpretation, which seeks to extract stability and attach it to a concept outside the text of the law, investment project, well, it applies to other stabilities, such as stability in respect of exporting the ore or receiving money from the central bank, guaranteeing a certain rate. All of those rights, which are spelled out in terms 9 and 10 of the contract, well, all of those need to be read to see how this theory would work with all those different types of stability. It has to be the same concept. So a systematic interpretation takes us to the same thing. I've gone on at some length, but I don't know if with this I've answered your question.
Just to make sure that I understand, So I understand you say because it is an adhesion contract, Annex 1 is stabilized, and regardless of how the concession evolves over time. So whether the concession named in Exhibit 1 comprises 463 hectare and 33,000 metric tons per day, or 8 years later it comprises 4 times more, it does not matter in your understanding.
Sí, no, para mí no es relevante porque
Yes, for me it's not relevant. For me, it's not relevant because the concept of stability under Peruvian law is a concept that does not limit stability to the specific investment. As Ms. Vega explained a moment ago, Peru's situation in the years in which these laws were adopted was terrible. Its main competitor was Chile, which had a more developed institutional framework, and it was credible, and Peru had no credibility. That's why if you look at the original versions of the law, with an investment of $2 million, I could get stability for the unit, because no one wanted to invest in Peru. So the legal arrangement is very attractive, and it's consistent with the international framework for stability. Now, what does this mean? Well, it means that if I make an investment, and I define an investment so as to comply with stability, and I undertake a feasibility study, and that feasibility study is viable, and that amount is greater than the threshold defined in the law, then stability is for the entire unit. Why? Because what is truly valuable about the contract or the agreement is not how much tax will be levied on me. Cerro Verde has paid more taxes than it was current at that time because it's been stabilized. It pays 30, and at the time it was 22. The important thing is that the stability is there, that the law is not, that the rules of the game aren't going to change. That's how one must interpret the contract and read it. Because so the definition of an investment. Well, if there's an investment that improves the concession, and the consideration for that is stability of the entire concession.
Then allow me just one follow-up question before I hand over to the Respondents' Council. In paragraph 8 of your second expert report, you make reference to a legislative decree confirming that these adhesion contracts under Peruvian law have a civil and non-administrative nature and may only be amended or cancelled by agreement between the parties. Mm-hmm. And also the stability agreement provides in clause 14 the contract cannot be modified unilaterally by any of the parties. Any modification must be made by public deed once the parties have reached an agreement with respect to such modification. So does the inclusion of the concentrator by extension of the beneficiation concession later constitute such a modification to the contract?
No. No, porque entra en el...
No, because it falls within the very scope of the contract, the agreement. The concentrator, while it's in, so long as it's incorporated as part of an existing mining right set out in the agreement, is covered. And the same thing happens with all investments made during the 15-year period of stability, so long as the modification is covered. One needn't change the scope because the scope is the concession, the economic administrative unit in this case. It's a set of concessions grouped under an economic administrative unit. So there's no need to amend the contract or the agreement. And indeed, at a given point in time, in the history of these three agreements, at some point in time, there was an intention to have an addenda to amend the scope because there was a concern of some overlap of the agreements, though that never happened. The addendum was proposed, and it was not done because it was said that that modification doesn't fit within the model agreement because it referred to a temporary change or a time change, and that never happened. There was an interpretation that allowed the two agreements to coexist. But once again, the modification wasn't made because it didn't fit within the model agreement, and it did not fit within the law.
Are you aware and have you analyzed that in 2004, Cerro Verde itself suggested an amendment to the stability agreement? Shall we show you the presentation which shows that, or are you aware of it?
Sí, sí lo he visto.
So I have seen it, and I understood that what was argued there, and I'm sorry if I'm not remembering correctly, if you're referring to that part of the presentation, that it was thought that the concentrator might be built in a different concession. So being a different concession, there one would have to amend Annex 1 so as to incorporate another concession to bring it within the scope of the concession. But that doesn't impede new investments in the existing concession from being covered. And I understand that that is what was executed. For at the end of the day, the investment was accepted within the same beneficiation concession. So at present, the stabilized unit is a unit that includes Cerro Verde 1, 2, and 3, and the beneficiation concession. Nothing more. It continues to be the same thing. What's going on in these units, so long as they're legitimate investments, is protected.
For you, the extension of the beneficiation concession to the concentrator is the decisive point in this case?
I understand that that is the case, also stemming from an interpretation of the contract or the agreement, but yes, because the discussion once again is whether the concentrator is or is not part of an economic administrative unit. My opinion, as reflected in my reports, is that what is stabilized is the entire table. The concession of Cerro Verde 1, 2, and 3, and which within the same area has a beneficiation concession. Everything that is invested is within the stability agreement because that is what's defined by law. And since the law so defines it, then it is protected. So as I see it, the concentrator is protected because it's incorporated into this concession.
Very much. Maybe this could be a good time for a lunch break. Or no, okay. It's not a good time for a lunch break. Please continue.
Now, continuing with your answer, following up on your answer to the President, I would like to remind you that there are 3 different stability agreements for Cerro Verde. One dates to 1994, another 2004, and another 2012. Now, if you make a comparison, I think that what we're hearing is fine, and it's been an excellent presentation, but I think the fundamental thing for the purposes of stability is the agreement, and the agreement, which in effect is made within a legal framework. But if you compare the stability agreement of 2004 with the 2012 one, in 2012, express mention is made not only of leaching, but also the expansion in the form of the concentrator. Doesn't this entail recognition of a mistake in the 2004 interpretation precisely because in 2012 this situation is addressed and it's said expressly that stability also covers the concentrator, which is understood and recognized by the parties, perhaps, with the interpretation of the 2012 agreement. With the 2012 agreement, the parties are recognized that it wasn't covered, that the concentrator wasn't covered before. How do you compare these 2 agreements?
Todo acuerdo tiene que leerse en el contexto. La interpretación textual.
Pardon. Sorry.
Pardon.
I believe that all of this needs, well, the textual interpretation needs to be accompanied by an interpretation of the context in which all this happens. If I'm told that if I'm assured that it's not going to rain and then it does rain, then the next time I'll take an umbrella with me. I think the thing is that as among the 3 agreements, rain had fallen. There had been an understanding, a correct understanding on the part of the investor, as I see it, as regards the scope of coverage, and then an interpretation emerged, which I believe is mistaken. And not only in my opinion, I think it's understood as a change in criterion. And so, of course, one tries to draft a contract so as to avoid, as happens all the time, depending on the context one is in. If one sees that a contract is clear and then it does not meet with compliance, then one tries to be even clearer. I think that's the reason. Isn't there a change? Is this a change in criterion, or is it a new $800 million investment, which is a very different situation from a change in criterion? Well, let's see. Once again, I think that's very important to understand the three agreements. Why are there three agreements? The three agreements exist because the idea was to have a stability which moves over time. What you cannot have are two agreements that simultaneously grant the same stability. That cannot be. Or you cannot have one stability regime overlapping with another stability regime. The three contracts move over time. The stability is the same, and each contract expands the level of stability. So, of course, an $800 million investment, but if you understand that it was already protected because it's the same economic administrative unit, then I don't think that is what's relevant. It could be 800 million, 1 billion, or trillion. Well, it can't be a trillion, but there are some investments that continue to be made. And then the change in name, well, names are given, well, in a somewhat, well, not arbitrary, but more or less fortuitous manner. So I think what's relevant is to understand the legal framework under which the agreement is structured. The concept of economic administrative unit is a central concept for understanding the entire logic of the agreement. And I repeat the same thing. The concept of investment project is not to be found in the law. There's no clause of the law, no article thereof, that mentions investment project. So I think that's what we need to look at. One must look at whether that's already been stabilized. And I think the answer is, well, was that or was it not stabilized? In my opinion, it was. What happens later doesn't add to or take away from what exists. You are a very recognized lawyer in your legal practice. Had your client said, I'm going to make an $800 million investment, there are doubts as to whether or not this is covered by stability. You would have advised them to ask the administration to recognize in writing that it was covered, that it did enjoy the protection of that coverage. Well, we lawyers can advise many things to improve contracts, and this takes me back to context. In context, it's always possible to obtain that. Had I told my client very clearly, I would have told my client, this is already covered by stability. It is, and of course, then there's a whole discussion as to whether I should ask for a written insurance policy, as was being discussed. You have to look at the context. What I think is that whatever kind of assurance one might have attained would not change the legal status as provided by the law. So I might have advised my client, take a precautionary measure, see if that is covered. In my opinion, would have been the same with respect to scope. That is protected. Thank you very much.
We are, of course, in the tribunal's hands. I'm prepared to continue if we wish for a bit before lunch. I'm completely, I want to just let you know that I am prepared to go right ahead if it is in the interest of the tribunal, or we can pause. It's up to you.
I think we have, for the time being, no further questions, so it's a good time for a pause. We only have 40 minutes, okay. And so we meet again 20 minutes to 2.